Sachin Kumar.
Which clearly says at page number 52 that you have mentioned your apprenticeship details in
Fifty?
page 52.
Yes,
This is similar matter in apprenticeship,
yes.
which clearly says that your period of apprenticeship period was mentioned as 6th of March 2018 to 5th of March 2009, while the cutoff date was 12th of April 2009, a month after their training. So this is the applicant is also in service production more than 2.5 years, and we have filed work on the parity basis because at Annexure 813 members, various OAs
Annexure?
Annexure 813 page
Tell the page number, what annexure is 13, annexure is A19.
134. 134.
Yes. London Council for the applicant submits that the issue involved in the present case is identical to that in various OAs, including in OA number 1444 of 2025. Pending adjudication before this tribunal, London Council for the applicant submits that this tribunal-wide order dated 24th April 2025 in OA number 1444 of 2025 has granted interim protection to the applicant. Similarly, in other identical cases, also the tribunal has granted interim protection to the applicant. Issue notice, London Council who appears for respondents on advance service accepts notice. This what you say.
Notice at page 52.
We are asking only simple thing today. Whether this case is identical to that or not, more or less.
It pertains to the same advertisement and super.
Down.
Below my objection and one point below that he has already put a reply to the show of notice. Therefore, we are only saying that let us may not consider whatever reply he has given to us and we'll pass an appropriate order. Today we have not terminated him. Only a stage of show cause notice. We have given him time to file reply. He has already exercised that right. He has filed his reply. We are considering it.
Have you filed the reply in those cases?
I have filed the reply.
You have filed the reply in response to
Yes,
his
in all the cases. In all the cases, I have filed the so-called reply notes.
See, try to be precise and very clear. You say that under challenge is so-called notice dated 15/10/2025, right? You say that the issue involved in the case is identical to that in OA number so and so, right? He submits that in this case where he is the counsel, he has come to know that pursuant to this so-called notice, you have preferred representation.
Yes.
Or your reply, right?
Reply.
Just a minute, reply. Have you responded to the so-called notices impugned in those OAs which you are referring to?
I have replied in those OAs. So the reply to the so-called notice has been filed in those OAs.
Take down. London Council for the respondent accepts notice. He submits. He has vehemently opposed the applicant's prayer for grant of interim relief. He submits that. Admittedly, the applicant, by way of the present OA, has challenged the so-called notice dated 15/10/2025. However, in response to such so-called notice, the applicant has already filed his reply, and the respondents are yet to take a decision in the matter. He submits. In such view of the matter, the applicant, instead of granting any instead of interfering into the matter, the respondents may be accorded liberty to pass appropriate orders, keeping in view the applicant's reply in accordance with the relevant rules and instructions on the subject. Learned counsel for the applicant submits that in all the identical OAs, including in OA number 1444, क्या बोला था जो भी 1444 such and such, 1444 2025 also, including 25, the applicants have submitted a reply to the impugned so-called notices, and the tribunal has granted the interim protection. In this view of the matter, he submits that for priority, the applicant in the present OA as well deserves grant of interim relief. Yes, sir. Do you say, Mr. Counsel, that yes, in those cases, he has not submitted reply?
Because the matter pertains to different divisional railway.
Yes, sir. Learned counsel for the respondent submits that in absence of any effective instructions and or a reply from the respondents, he is not in position to tell as to whether in the identical ways the concerned applicants have replied to the impugned so-called notices or not. We have considered the submissions made by the learned counsel for the party in the aforesaid facts and circumstances, and for priority as interim measure, respondents are directed not to pass order of termination pursuant to the impugned so-called notice dated 15/10/2025 till the next date of hearing. Learned counsel for the respondents and is allowed 4 weeks time to file counter reply. Applicant may file rejoinder if any within 2 weeks thereafter. Stop. As the respondents are the respondent shall be at liberty to approach this tribunal for vacation/modification of the interim order passed today. However, of course, after by way of a miscellaneous application. However, after filing of replies or replies based on such and such date.
19 दिसंबर
मैं जो पहले किया था वैसे ही एकदम अलाउ कर दो क्या
19 दिसंबर
नेक्स्ट
आइटम 7 डॉक्टर मनोज कुमार